morning, everyone. I take Claire's instructions under strong advisement, and I'm just thankful that I'm not later on in the day where I'm trying to dress up the issue of adjudication for the fourth or fifth time and pretend that you haven't heard everything you need to know about it already. So in light of the time available to me and the fact, as I say, that there will be other presentations that you'll hear, by necessity I just have to look at a few key points. So the first issue is, what do I mean by the hook that I've given the talk here, the only game in town? Trying ahead of adjudication commencing at the end of July to see where it might sit in the wider legal landscape. So the first issue would be that there would be a reasonable expectation at some point that you're going to see challenges to the Construction Contracts Act. And so the point that you maybe more so in the recent past have heard at the sidelines of events like this rather than at talks is the issue that arises from Section 8.1 of the legislation. So the canard that Dr. Bani was improperly appointed. So it's been so frequently discussed, as I said, at the margins of events like this and otherwise, that if I'm invited back to the 2017 construction summit, I would be very surprised at that point if there hadn't been a challenge arising from that point. So the logic is that people have taken a very literal approach when they look at this idea to Section 8.1, and they formed the view that the panel of 30 or so adjudicators should firstly have been appointed, and then the chairman should have been appointed subsequent to that. I'm not sure myself that will go anywhere. I understand the logic behind it, but I take the view that the presumption of constitutionality and public policy would see the argument, as I understand it, that Dr. Bani was appointed chairman of a group that consisted of himself is probably sufficient. So he was first, as I understand it, technically appointed an adjudicator, and then a period of time later he was appointed to chair a panel that just happened for a short period to be made up of himself. So I'm not sure that there was a necessity to do it that way. There's an argument that it's awkward and ugly and a foreseeable challenge would arise, and it could have been avoided by structuring it in a different way. But I'm not sure myself that argument is going to go anywhere. But I would imagine that somebody, depending on the particular facts of their own situation in a construction dispute, will probably try and run with that argument. And in the finest traditions of law, they'll probably have, a number of other arguments along with that point. But that's the issue that on the slides there I describe as teething problems. So beyond that specific issue of the proper construction of Section 8.1, there are wider issues that people would have been familiar with, and this is where I get into trouble, and I'll repeat some of either what Claire just said or what Joe Bean or Jim Bridgman might say later this afternoon. So the wider issues that could be thrown up in relation to adjudication, the sledgehammer to crack a nut point, the European Convention of Human Rights point, ECHR point. So the the expeditious nature of the process balanced within the Irish constitutional framework, and that's an issue that's been well canvassed. So, as I say, I just came at it this morning in a slightly different way and flagged the issue of Section 8.1 to you. So the first point is that the legislation here doesn't apply in relation to certain types of disputes. There are the exclusions there. The legislation isn't retrospective. You need to have a construction contract that is kicked in on or after July the 25th, so there will be a time lag. Disputes that have arisen before that date or from contracts signed before that date will continue to be determined in the normal way, whether that's conciliation, arbitration, or litigation. And then the other issue, and I can't pretend that I didn't hear Claire talk about it. We don't know certain things at this point. It may be a lacuna in my research, and I apologise to it, but I take comfort from the fact that I think I heard Claire say that the rules of the Superior Court that relate to adjudication, so the amendment to, from memory, Order 56 has not come out. So from the viewpoint of the rules of the Superior Court's Committee, where's the rush? From the viewpoint of people taking an interest in what will happen here, it would be helpful at some stage to know what form the rule will take. I've heard with reasonable authority what people think the order will, in the way in which the order will be designed, but it would be nice to see it. It would be nice to see it in actual hard copy form. So we don't know certain things at this point. We don't know the effect of the challenges that might arise, and then there's a more intangible issue that we can't really nail down at this point. If you haven't worked out by now, you're not getting anything terribly original from me, so I'm coming back at this point to be unoriginal and to refer back to Mr. Justice Thannady, who's the most and Mr. Justice Clark. So in an Engineers Island speech a couple of years ago now, and more recently at the Adjudication Society conference last month, they both spoke about the intangible point that the degree to which the system will work will depend on how confident the users of the system are with it, and that by analogy, if you talk to people in England and Wales who remember the introduction of their Housing Act in the late 1990s, they play the legal equivalent of what would have happened if Muhammad Ali had fought Mike Tyson and so on. They get into things that you'll never know. If those early decisions in England and Wales had been heard by different judges, or if they had played out in a different way, would the system have worked there in the degree to which it did? So a suggestion that most people would be uncomfortable with, that there's an element of happenstance to how well a new legal process or legislation would work. So to try and gather the ideas that I've that I presented to you. Adjudication at this stage can't be the only game in town, because there's a potential in the operation of adjudication at a later point under rules of the Superior Court where challenges arise, that there's some problem that none of us really fully appreciate at this time. So it also theoretically can't be the only game in town because of the ECHR point, that because it's not as fulsome as some other dispute resolution methods, to avoid issues under the ECHR, it's notionally not final. And then talking about what will happen when it's not happened yet, we obviously look to other jurisdictions, and in other jurisdictions, as remarked by David Brynmore Thomas in 2013 in the talk at McCann Fitzgerald, the suggestion is that many construction lawyers find themselves telling clients after an adjudication hearing, yes, of course, I agree with you, the adjudicator got it wrong, but he or she did not get it so wrong that I can, with a good conscience, advise you to do anything else. If you balance up what's at issue in terms of the time and costs that would arise from going forwards, this is one where you're just probably going to have to take it on the chin, so to speak. So, what are the other points to bear in mind? The suggestion that I would make to you this morning is that there's a possibility that even though it took 6 years to get to this point, or because it took 6 years to get to this point, the legislation may be amended sooner rather than later. The legislation was introduced as a private member's bill by former Senator Quinn in May 2010. It was introduced in a very particular context in the Irish economy, and we're getting on from that period in 2007, 2008, 2009. It's going to soon enough be 10 years since then. So there's a suite of adjudication legislation around the world that is similar to this, but in some instances it's got a wider scope. So if you look at other legislation in terms of, say, landlord and tenant legislation, in terms of disputes in relation to issues covered by the PRTB, legislation that has set up ADR-type processes has been amended relatively quickly. Every 3 or 4 or 5 years, it's often the case. Legislation in relation to quasi-judicial processes or determinative processes outside of the courtroom. So, for example, going out of the sphere of construction law and looking at the Mental Health Commission, it's quite common that you get legislation that revises the process. There's a series of Residential Tenancies Acts, there's a series of Mental Health Acts, and I'm going to wonder aloud, along with the point that somebody will by the third version of the construction summit have advanced the proposition that Dr. Bunny is improperly appointed, that there will probably be a desire at that point in 2017, if the process has been seen to work quite well, to look at whether it's necessary to expand it. So I will draw to a close. I share a few problems at moments like this, excessively quoting David Brynmore Thomas and Niall Fenley and so on. Also, not changing my photos, that's what I used to look like, but more relevantly, my email is below there. So I won't go too overboard, but Claire probably introduced me as editing the construction journal that I do. So if I can ask you to bear with me, I'd be interested, obviously, as it's a room of people who are active in that area. If anybody had an interest in reviewing a book or writing an article for me for that journal, you might email me adhussey@lawlibrary.ie, and hopefully not having spent too long on that little plug there, I'll just go back and try and finalise the remarks that I've made this morning. So it's been 6 years that we've waited for this, so it's difficult for people to have realistic expectations about it after 6 years. Some people will think that it's been overrated, overdone, and they'll be negative about it, or they'll have switched off and not even at this stage thought about the implications of it because they've been waiting for it for so long. Other people will have overdone it. They will think that this is the only game in town, and the complicating factor as of the middle of June 2016 is you need to see whatever challenges are brought before the court, however spurious those challenges may be. You need to see the amendments to the rules of the superior courts. You need to see how the adjudicators panel works on a day-to-day basis, so as to address the point that Fennelly and Clark raised about the intangible point that for the system to work, people have to trust the system. Okay, well, I thank you for your time, and I hope you enjoy the rest of the summer. Thank you.